And I'm sure he has disagreed, he didn't tell me that, in the government many a time. But if that's what they want, that's what you got to give them. So he might have some schizophrenia in this matter, said in a positive way. He may believe in what he says, he may not entirely, but he has to defend the realm. But I hope today, with this nice crowd, he will tell us a bit more of the insight, how some recommendations have gone up from the Commission, to be fair to them, and government has rejected. Just like Sohakam, we made lots of recommendations, but government did not accept all of them. So don't blame Sohakam. Having said that, I have now great pleasure in inviting our Dr. Wirawan Ahmad, the Deputy of the Election Commission. He is an expert because he's been there, I think, the longest serving officer. So I congratulate him for that and welcome him. Dr. Wirawan. You can sit or stand. It's a free country.
Assalamualaikum, salam sejahtera. Good afternoon, ladies and gentlemen. Yang berbahagia Tan Sri Nabaranam, yang berbahagia Datuk Ambiga, yang berhormat Datuk-datuk, tuan-tuan, saudara-saudari yang saya hormati sekalian. When we received the invitation from Proham, I got a letter from the SPR, EC got a letter from Datuk Dennison. We were informed that it was going to be a roundtable discussion. So, very frankly, I was looking forward for a roundtable discussion. So, but anyway, we are now in this hall, and we are going to discuss something of very important to our country. I had a tough experience last week when I attended a Wacana. Wacana is a kind of forum ilmu, discussion. But it did not turn out to be Wacana. The crowd that came, they did not want to hear what I wanted to say, because they did not want to listen what they don't like to hear. So I didn't get a chance to tell a little bit extra what I could tell. Being in the public service, we cannot tell everything. We wanted to tell, but we cannot tell everything. Because there are things which, in the eyes of the government, in the eyes of the authority, the subject matter is still considered confidential. Shouldn't be a public discussion. So it is going to be very difficult when you talk to in a public forum, especially in the open discussion, when you have things to tell, but the rules of the game is that you cannot tell. Okay. But anyway, for today, when SPR received invitation from Proham, I was, as I said, I thought a roundtable discussion and comprised of 30-40 people, as indicated to me by Dr. Dennison. But now it is a public discussion with media, and nothing to stop media from reporting what is going to be transpired in this room today. So that's another constraint on my part. I hope, gentlemen, ladies and gentlemen, you understand. So, you see, in our country like this, when the political divide is so strong, You have, now we are moving towards a big coalition of parties. It is good for the government. I mean, it is good for the country. We go to any advanced democracies in the world, we see a big coalition of two-party systems. And they are moving very well. A clear choice for the people. And that is exactly what is happening in our country, which is good. Then SPR is sitting in the middle. When we sit in the middle, it is very difficult to satisfy everybody. That's number one. From my experience, you do something to the liking, to the acceptance of one side, the other side will say no. And once the other side has made up their mind, they refuse to change anymore. So that's why we need Wacana, where we can open up, we can see where we can find the middle ground. Perhaps something which was not happening. Wherever we go to discuss big matters, if it is in the public hall, in the public discussion, it is very difficult, to come to a point where we can find something that we can agree. Because it's already preconceived that is bad, that is bad, that is bad. No way. You can only proceed as what we feel good. That side said, no, that is not good. And there C is in the middle. Election Commission is in the middle. And then that's one thing. And the background of our country, I've been saying this all along. In our country, the division of responsibility is very clear as far as the laws are given to us. Maybe some people in this hall don't like to hear this, but I'm going to repeat. We are guided by Attorney General's office that the laws given to us are the management laws. We are the election management bodies. Some people don't like to hear that. They said, no, you are also an enforcement agency. Then I said, no, we are not enforcement agency. You are talking about dirty politics, money politics, book buying, and whatever you want to say in the context of corruption in politics. The MACC is there with all the investigators, with all the powers in their hands to go after the culprit, go to court. SPR can be called as respondents. We can call as witness. We can say in court what we feel about it. But never before in the history of this country where Election Commission take a person on the ground of corruption to court. So we had one clause under Election Offences Act which says pasukan penguat kuasa kempen pilihan raya, enforcement team, kempen pilihan raya, enforcement team. And when they gave that law to us, that law was meant for us to monitor the activity of campaign, the display of posters, because what they are going to say in the ceramah are all being controlled and handled, monitored by the police. There is a police act who govern and control the ceramah, and the police are the one responsible to monitor the ceramah. But Election Commission enforcement team merely to monitor the display of posters in accordance with the law, what are written on the posters, and things like that. So that is briefly my opening remarks, because I thought Ansari said maybe 5 minutes, I thought earlier. So I will stop at that point. Probably we can discuss further as we proceed this discussion. Thank you.
Terima kasih, Wira. I think you have taken this concept of round table very seriously because you have restrained yourself with the constraints that there are. But maybe we can try and make you more comfortable that, you know, it's after all a good intellectual or civic sort of discussion. But what struck me really is what you said, and which I agree, that difficult for you to make too many open secrets, so to speak, in public. But maybe you have given us a good opening to have a Wartana at some stage, maybe 5-10 of us get together and have a more open discussion. I think one question I'll register with you, others can raise it, is I feel, I don't know whether others agree, that given your constraints, the Election Commission could have all these years been seen to be more independent and more proactive. Well, that's my question. If you all agree, we can ask Dato' Wira to answer later. Now we come to another star who will become a household word. Dato' Ambiga. They say, and as an older man, maybe I got the license, that she's young, obviously younger than me, very bright, obviously brighter than me, and charming, and yet highly pertinent, particularly to our times today. I have great pleasure in now inviting her to address us. That's all.
Thank you very much, Lansri and Dato' Wan Ahmad. Let me first start by responding very briefly to Dato' Wan's comment. And of course, he was in the hot seat on Tuesday. I don't deny that. But the reactions of the audience, I think there have been criticism about them. But my own view is when, as leaders, I mean, I don't consider myself a leader, but as leaders or persons in charge of organizations, if people are angry, you have to respond to them. The answer is not to shut them out and to talk down to them. You need to understand their anger. And I think a lot of the questions that day, with due respect, were very fair questions. They were questions about indelible ink, they were questions about the role, etc., etc. People may have been a little bit emotional. But I think it is important for leaders in this country to understand the anger of the people and to understand why people are angry. And a lot of it is actually because they're not getting answers. And I think that one has explained his constraints. And that is very annoying to the people because they're not getting any clarity, any clear answers to the questions that they have. Having said that, and in fact, one of the participants, or a couple of them, were quite rude when they asked me a question. But I understood, rather than shut them out, I said it was important for people who have a grievance, for them to have a response. And I think that's the way forward for me. Now, as far as Bersatu is concerned, Dato' Shami, hello. That was sweet. As far as Bersatu is concerned, I'd like to say that we are not the first to ask for electoral reform. People have been asking for electoral reform in this country for the longest time, for the last 20 years. In fact, if you look at academics, there's a book actually by Mavis Puducherry and Noraini Othman, which contains, it's an excellent book. 2005 this came out, and it has several articles by very distinguished people as to reasons why there should be changes to the electoral system. So really, the problem with the reforms, and let me tell you, since the 1970s there have been a lot of reforms, there have been a lot of amendments to the law. And certainly after the 1999 elections, I can tell you there were 32 amendments to the election laws. So, and by the way, there was also an amendment to the Constitution, if you recall, to extend the retirement age of the chairperson of the Election Commission. This was in either 2007 or 2008. So, reform of election laws is nothing new, and it has been taking place. The problem is that the election laws have been amended, possibly not necessarily to make the to make the playground more even, and that is really one of the complaints. That the amendments actually, if you notice, for example, after one of the cases, the Likas 2 case, in fact, from Sabah, there was an amendment which said you couldn't challenge the electoral roll. That amendment came about in 2002 because one of the grounds in that case was that there was a problem with the election rolls. So the amendments just keep seeming to take away from the level playing field, or rather making it more uneven, as it were. So we are not the first to ask for electoral reform. The reforms that we have asked for are not new. They are not new. These are problems that have existed in the past. Now I'm going to run through very quickly. Doesn't work. All right. If you just look at the slide, what we are asking for, if you, these are the figures. There are 3.7 and counting, by the way, unregistered voters as at today. Now, when I say unregistered, it is possible that they have actually gone to the post office or wherever it is and filled up the forms, but they have not got onto the electoral roll. Now, the problem is there is a lag period between going and filling in your form and getting onto the electoral roll. That is a problem. And we have, there is a backlog, and perhaps that is something that one can address later in response. I understand there's a process, yes, but it cannot be more than, it cannot take more than a couple of months to get through that process. Now, we have 12 million registered voters. One of our first tasks is in relation to phantom voters and other fraud, as well as disenfranchisement by virtue of impersonation, illegal transfers, and other things. So those are some of the things. Phantom voters, you know what phantom voters are. Impersonators of the dead, impersonators of legitimate voters, non-resident voters, and multiple registered or fraudulently registered voters. Now, I will come to showing you some evidence of that shortly, but one of the issues is, why is it that deceased persons cannot be removed from the electoral roll? This is an issue that Per se is quite concerned with because it's tied up with the NRD. It's not necessarily the EC's a problem that is EC's, it is a problem with the NRD. And what they say is, what EC has suggested in their responses is that those who have lost relatives should go and remove their names from the NRD. Now, I'm not clear on why that is necessary, because in this country, you can't, it is very appalling to me that a national registration system cannot detect whether a person is dead or alive. And we know that there are many cases of people who are on the register, on the roll, who are more than 100 years and so on. So how is that happening? Now, if it is a problem with the NRD, then it has to be sorted out, which is why I also have misgivings about the biometric system, although I'm open to hearing about this. The biometric system, if it is going to be tied up with the NRD database, then we have a problem, because the NRD database doesn't seem to be able to capture, I don't know if I'm right or wrong, and perhaps someone from NRD should also be here to respond, to be fair to them. Why is it they're not able to capture people who have passed on? I find it difficult because you need a death certificate, you need a burial certificate. You cannot proceed to bury and to carry out last rites without all the necessary records. So explain to me why the NRD cannot capture that information. I don't understand it. You can capture births, but you can't capture deaths. I find that difficult to believe. So the other thing is, okay, this is an example, all right? There are two people, you look at the names, Lanuddin and Lanuddin, you see that there. The same IC numbers, registered in two different parliament constituencies and state constituencies, all right? Then the second one is the same person, Parvati, slight variation, and then you have them registered in two places. This is only one of many, many examples. We've got a whole list. We've got a whole book, actually, of examples of such registrations. Now, what we have, this is another example where you have the husband on the left-hand side, Ong Ah Hock, who is registered in one constituency, and then the wife and the in-laws registered in another, all in one household. Okay, so that's another example. Now, these are other things that we have found. The last bullet there, the tie between voters and constituencies can only be changed by voters or the parliament. Now, what that means is this: you can't move a voter, and I think Dr. Wan has said this in their booklet, you can't move a voter unless they apply, and you cannot shift. You cannot shift. You see, what happened, if you recall, there was a case in Hulu, Selangor, of, I think it was 282 or 272, who were moved, voters who were moved by the Election Commission. And they have regulations that apparently allow them to do that. Now, to me, that was like a redelineation. You have actually shifted the boundary by doing that. And how does that tie in with the sanctity of the electoral roll? Because the electoral roll cannot be touched, in a sense. And I think the EC does acknowledge that. But they admitted making these transfers, and we were concerned as to how that happened. But apparently there is a regulation that allows it. Now, in our view, that regulation cannot be correct. It is actually ultra vires the act, because the electoral roll, once it is entered, is sacrosanct. So in fact, when we ask for cleaning of the electoral roll, we do acknowledge that you may need some statutory amendments, some amendments to the legislation to empower the EC to clean up some of these issues. And that is something we should be looking at. Now, the other thing is, we have suggested, per se, that we have automatic voter registration. Now, the good thing about that, you may need some amendment, constitutional amendment in relation to updating, as I said just now, where you want to change, where people move around. But we think automatic voter registration is very doable. And what it does is it gets rid of this registration process. And I know that Dr. Wan has pointed to a provision in the Constitution that seems to suggest that you actually have to go and register. But that is easily rectified. That is easily rectified either by a constitutional amendment or by a deeming provision that says that you are deemed to have applied to register upon your attaining 21. The beauty about this is, and this really, if they are looking at the biometric system, and if our NRD database has integrity and is absolutely clean, automatic voter registration is very doable, because it all ties up. And you do away with the registration process, which means everybody automatically can register, can vote the minute they attain 21, which is the way it should be under the federal constitution. So that's what we like about the automatic voter registration. One of the arguments against automatic voter registration is that it means you are forcing people to vote. Now that's not true. No one is forced to vote. You just become a registered voter. Then it's up to you whether you vote or not. The other argument was that then you have a larger percentage of people who don't vote. What does that matter? What does that matter? Because actually, I think you will find a larger percentage of people who will go out to vote, because a lot of people are lazy about going to the post office and registering to vote, although the process is very, very simple. Now, indelible ink versus biometric. This is another issue. Biometric, I have got a lot of responses recently on the biometric system, and there are people with misgivings, although I think we should be open to it. But I think the EC must fully engage the Rakyat on the biometric system. We must hear from the experts. We must have an audit done. The tender process must be absolutely transparent. Every bit of this process must be transparent, because people must trust the system. It's like going to a bank and doing electronic banking or ATM. It's because you trust the system that you use it. So people must trust the system. And I understand, Dr. Wan, that there are some issues, but you may be looking at it. Older people have problems with the biometric, because there's some, and also there's some about taking the thumbprint and so on. So those are issues that I think EC has to look at. and also if your hands are wet, you know, little things like that, which could, those are things I think EC can take on board when they are looking at the biometric. But the key for the biometric for me is you must engage the rakyat. A lot of people have a lot of views, and these are people who are experts in these systems. 5 more minutes. All right. I'll talk about indelible ink when you question me on that. My concern about biometric, can you actually get it done by the 13th general election? If you cannot, we would suggest, please continue to look at indelible ink. It's a cheap alternative and it really works. It has worked in other countries. It's worked in India, it's worked in many other countries. Now, all right, malapportionment is another issue that we have. You can see that there are constituencies that are drawn up that vary so much in sizes. Kapa, 112,000, PJ Utara, and Sungai Besar. Now, that is something perhaps I can come back to, but you will also see that there is a lot of malapportionment between constituencies. Now, under the federal constitution, the idea about delineation is that the idea is to tend towards equality of the weight of every person's vote. So in other words, if I'm in a constituency of 100,000 and say Tan Sri is in a constituency of 50,000, his vote is valued at double mine. When in fact, under the federal constitution, the idea is tend towards equality. Of course, you can take into account geographical issues and so on, I accept that. But we have found, for example, in the slide that I'm showing you, that the state boundaries are in dotted lines. You find things crisscrossing, constituencies crisscrossing all over the place. So you could have 3 local authorities, for example, within one constituency and so on. So it's very difficult for an MP to actually administer in those constituencies. Now, I'm going to move on to postal votes. Yes. Okay. Yeah. Postal voting. Now, this is absolutely key. Yeah? Postal voting, which I didn't have a chance to cover the other afternoon. This really does cause a problem. Now, what you have is you have certain parties who are entitled to register as postal voters. And you see they are military personnel, spouses by choice, so spouses can also apply. And then you have civil servants overseas, tertiary students overseas, although I can tell you from what information we have got, many of them find it impossible to actually vote. Now, you also have, we want to ask the question, why overseas Malaysians are disenfranchised totally? Basically, if you register as a postal voter, you cannot come back and vote as an ordinary voter. That's the other problem. But if you register as a postal voter and you go overseas, but there are no provisions made for you to go and vote, you have effectively disenfranchised all those people. And we have got feedback from overseas voters, and they have said that it's impossible to go to the embassies and vote, and only certain people are allowed to vote. And this is something that I hope the Election Commission, and I think Election Commission has said they will look at it, so I hope that we can do something about that. Now, I just want to say this about overseas postal voters. This is very much tied up with the longer campaign period. Campaign period is too short. In the old days, you had 42 days, and so we're not asking for 42 days. We're asking for minimum 21 days. But if you want to make postal votes effective, then you must allow more time. Otherwise, it can't be done. Otherwise, you know, it's a joke. So the other thing is, when you have people in Sabah and Sarawak and vice versa, you can use postal voting. And a lot of Sarawakians in the recent elections were disenfranchised because they were not registered as postal voters, although that is something that we had asked for. So what you're doing is you're forcing some 50,000 to 200,000 Sarawakian voters to fly back to vote from West Malaysia and Sabah and vice versa, when in fact all you need to do is to allow for postal voting. So this is something else, even within our country. I would ask the Election Commission to please look into that and see how you can facilitate. Because to me, the Election Commission should be facilitating voting. as much as possible, not hindering. And this is what we think they should be doing. Now, the other thing that is of concern is, of course, we've had news of the territorial army, one in each constituency to be set up. And we would ask the question, are they going to be counted in as postal votes? We would ask the Election Commission to answer that question if they would. Because we want to know, rather than seeing postal votes increase for people who are here, we would like to see it decrease. Because when the whole point about postal voting is to deal with absentee voting, which means you have to be absent. But we find that with military, you have a lot of people who are here and who are made postal voters, and we want to know why. Of course, they say you need them for security and so on, but I'm not so sure about that. Yeah, well, we have a lot to talk about. I mean, I think, can I just say one last thing, Tan Sri, because I need to talk about the Election Offences Act. We have always said that the Election Offences Act gives the EC power. You've heard Dato' say just now that it's only to monitor whether posters are up and what happens during campaign period. Let me read to you the functions of the enforcement team. It says the functions of the enforcement team. This is set up by the EC. The functions of the enforcement team, there it is up there. To patrol, to monitor the activities of the candidates in its area of control, to ensure that written laws relating to elections are being complied with. Now, what is the meaning of that? If it is just to see whether posters meet the right, it is much more than that. Because election laws includes Election Offences Act. Election Offences Act covers bribery and treating and so on and so forth. So, in fact, they have all the powers, and under the federal constitution, they actually can call upon, and this is under 114 or 115, they can call upon such number of persons may employ, so 115.2, all public authorities shall, on the request of the Commission, give the Commission such assistance in the discharge of its duties as may be practicable. So they can actually call upon all these bodies. Now, what I'm saying is this: whilst I agree with Dr. Wan that they don't have the power to prosecute, I agree, and I am thinking they should relook that. They don't have the power to prosecute. Nevertheless, when they see an offence, by virtue of what is said in the Act, they have a duty, in my view, to actually report that. If they see offences being committed, that is the reason for the enforcement team. Otherwise, the enforcement team is pointless. They have a duty to either make a police report or make a report, or to call upon various public authorities to see to the enforcement of the election laws. Because if they don't see to the enforcement of election laws, I mean, I don't know who can. I will stop there for a moment. I have other things, but I will put it in my responses to your questions. Thank you.
Thank you very much, Dr. Andi. You can see that she's full of it. She's fired with enthusiasm to resolve these outstanding issues. From my perspective, I can see there is a communication gap, and there is also a gap in the understanding as to what the law is and to what extent it can be made more effective. But we will give Dr. Veera time to go through these things later on. Now I come to our final speaker, Dato Sri Muhammad Shafi'i Abdullah. We were colleagues in Sohakam. I remember we had good times together, arguing together against the chairman of that time. But we had a lot of fun. We knew how far to go, how far to sort of step back. But I think on balance, we won a few arguments. Now he's elevated to the position of ASEAN Human Rights Commission. So I would expect him, personally of course, to be as active or more active than Dato' Ambiga, because he's covering a wider field, and he got more people to support him from outside. So with that expectation, I now invite him to address us. Thank you.
Thank you, Tan Sri Chairman. When I was on my way here, one of my legal assistants popped in into the car, literally as I was about to drive off, and said, perhaps you need a copy of the ASEAN Intergovernmental Commission for Human Rights, terms of reference. And I scolded her immediately. I said, what has that got to do with today's matter? Because I'm going to speak about the process of election. And I'm not going to speak as a member of the commission.
You are allowed from the chair to speak as member of the ASEAN Commission.
Now, I regret not having taken it now that Mr. Chairman has put it in a fix. But I must say this at the very beginning. In the commission, we are not allowed to speak as a commission or representing the views of the commission. But what I can do today is perhaps whatever I'm speaking today is my personal view. It may carry some weight by virtue of the fact that I'm a member of the commission, but I'm not speaking as a commission. If that can be made clear, I will now proceed with whatever I have to say today. Mr. Chairman, I must say the next sentence very carefully, because I have been often cited by the Bar Council for some kind of misconduct in terms of advertising. Now, I have to be very careful with this. I must say this, and I must quote the book by Sophia Jiwa. Sophia Jiwa, in the index to the very celebrated work on election laws, at the end of it, it puts the name of people, counsel who has been sort of hit with a lot of numbers of time as appearing in the election cases. And I was glad to find out that my name was the highest, meaning I did more election cases than any lawyers in the country.
Without advertising, let's give him a clap.
Now, and then came names like, and I felt very humble when I realized that next came the names of people like Raja Aziz and so on, the late Raja Aziz, my actual guru actually in election cases. Now, the reason I mention that is this, not because of advertising, but because I must say and stress that I have not come across issues that are being raised, most of the issues that are being raised by either Bersih or anyone else who sort of share the same sentiment as Bersih in most of the election petition. That I must make it clear. The best way to challenge an election petition, or rather an election result, is by way of election petition. In fact, you got no other way. When Dato' Ambiga mentioned that in the Likas case, there was disallowance of any challenge on the electoral roll. In fact, they stopped the challenge. I see. All right. Now, it was allowed in that case, but apparently they amended the law. But the current law is that you cannot challenge the electoral roll by way of an election petition, which I think is sensible. And that goes, that seems to be consonant with the rest of the Commonwealth. Now, I have delivered a paper on this at the previous Commonwealth Law Conference on purely on election in Jamaica. And we found out that 91% of the Commonwealth countries, in fact, subscribe to that view. You cannot go by way of election petition to challenge the electoral roll. The only way you can challenge the electoral roll is to go through the normal procedure of judicial review or such like, rate action and so on. Election petition is meant for purely to challenge the results of a particular election. Let's get that clear. Whether we want to change the law or not, it is another story, but I personally believe that election petition should remain pure as it is now. Now, second is I must also make it clear, and I find this very pleasant to say, that whatever is the checkered state of the election laws in this country, it is no longer possible to say that the current state of affairs is going to benefit one party or the other. Because I personally have seen the same provisions in one election seems to have favored the government. In the next election, that very same section is being attacked by the government against the opposition. A typical example, I will say this. I had, in fact, Justice Arif, he was then Encik Arif, a very eminent counsel, including election cases. He represented Idris Kamus. You remember Idris Kamus was one of the candidates in, I believe, election, 2 elections away. And his complaint was, in Selangor, without proper announcement, without proper gazetting, they have increased by 2 hours the period for polling, casting the votes. Probably because of some, there were some disturbances. The Election Commission officers thought that they should extend it by 2 hours. Of course, they were honest about it when they extended it, because when you extend 2 hours, it is extended for everybody. It is not just for UMNO, it is not just for MCA, it's extended to everybody. But Idris Kamus took the matter to court and said, look, you can't do that, because once you fix it, you fix it. And whether it affects the election or not is irrelevant, because the transgression of election law is so serious that the election must be declared void. Now, that was the point taken by Encik Arif, a very valid point, and his biggest support was this landmark case called Morgan and Simpson. Morgan and Simpson was our law, as taken up in Tanjung Puteri, for instance, by a very celebrated judge who knows election law like the back of his hand, namely Justice Wan Yahya. Unfortunately, we do not have calibers like that anymore, who understand election law so well in the judiciary. And I say this with the greatest of regret. I will come to the judiciary in a short while as to how they have failed the election process itself. Now, I was asked by the judge in the election court as well as in the federal court whether I subscribe to the idea Encik Arif has propounded. I stood up and said I support the idea that Morgan and Simpson is applicable in this country, in spite of the fact that the former judge, Justice Hamid Muhammad, who was then Justice Hamid Muhammad in Shah Alam election court, seemed to have overruled Tanjung Puteri. Of course, there is no overruling because they are all court of equal competence. And I said I disagree with Justice Hamid Muhammad's decision because Morgan and Simpson is subscribed to by 95% of Commonwealth countries. A decision of Justice Lord Denning. The principle in that case is that in order to maintain purity of election, in order to maintain secrecy of ballots, and in order to maintain democratic principles in election, which are the 3 pillars of election, you have 2 rules. And they have interpreted what Denning said in Morgan and Simpson in Tanjung Puteri to be this. If you look at our section 32, which is the basis upon which you challenge any election result, section 32 simply says this. I'm sorry that I have to refer to this. It says this: avoidance of election on election petition. The election of a candidate at any election shall be declared to be void on an election petition on any of the following grounds only, which may be proved to the satisfaction of the election judge. And the one that I'm referring to is B. It says non-compliant with the provisions of any written law relating to the conduct of any election if it appears that the election was not conducted in accordance with the principles laid down in such written law. And the word N is put. N, that such non-compliance affected the result of the election. A very similar wording appears in the British Representation of People's Act, 1948. And there, Lord Denning interpreted in Morgan and Simpson, he says, is 2 limbs, and they are disjointed. They are not to be read together. Namely, if you find that the processes in the election by and large, substantively has not been complied with, even if it does not affect the result of the election must be declared null and void. So there must be substantial deviation from the election law. Second limb, he says, is that if there is even the slightest breach of such election law, but nevertheless it affected the result of the election, then the election shall also be declared null and void. Now, in spite of both the council suggesting to the court that Morgan and Simpson is right, both courts, the election court as well as the federal court, decided not to follow Tanjung Puteri, but follow the wrong decision in my mind of the Shah Alam election court. Now you're stuck with this particular principle that the only way you can challenge and under that provision and declare an election void is to prove, which is an onerous task, is to prove that not only there was in fact substantial deviation from the election laws, but that such substantial deviation in fact affected the result of the election. So two ingredients which ought to be treated separately has been put together, conjunctive. Now we are stuck with it. Now, one election later, I took up the same point, hoping that I would be able to set aside this particular decision in Idris Kamus, and I ended up in the federal court, and I actually submitted. This time I was representing the petitioner, and this is illustrative of the point that I'm saying. Any defects in the election law or processes affect both parties. I do not believe for once, except for perhaps very, very rare instance, which I have not come across, that a particular defect in the electoral processes will benefit a particular party or the government in power, because it is no longer true, because people have changed in this country so much so that you can't say that the ballot papers in the postal box are always going to be for Barisan Nasional, because I have witnessed this to be completely different in Terengganu in the previous two elections. I found this to be completely true in some parts of Sabah, where the postal votes in fact sided the opposition. And I think this is going to be more and more true, where one party cannot actually say, well, the election processes and the laws are in our favor or against the other side. It is no longer true. Now, that is to illustrate to you the situation where judges have not actually addressed their mind as to the basic principle in achieving purity of election, which is what I think Dr. Ambiga is harping about. Let's have election in its purest form. Now, to achieve election in the purest form, some of these principles judges have to appreciate. In fact, I have seen many of these judgments where the principles of purity of election, principle of secrecy of ballot, and the principle of democratic process have not even been alluded to. And yet, what they do is to just to go down into the details and decide as though it is a mathematical problem. Now, that is one area. I have met a similar problem in, for instance, in two elections away, in Terengganu, where I think the Barisan Nasional won in the end, and they captured the state. In that particular election, we had a person who was tipped to be the next Menteri Besar of Terengganu. He lost the election because there was some issues with the postal votes. The petition that I filed on his behalf was purely a petition that relates to postal votes. This is to illustrate to you that it is not necessarily the government of the day or the Barisan Nasional who is going to benefit postal votes defects, if there was any defects. I have compared provisions in the UK. I found them to be rather similar. They vary in certain ways. Like, for instance, I agree that when the actual polling process, the voting process itself is being done, perhaps the election commission officers ought to be there with the respective agents. But what we have is, we have immediately after the election process, the polling process itself, the first counting process and the recounting process are done properly. But the main process itself, we have, our system have trusted it to the various agencies, namely if it is the police officers who manage their own affairs of the election process. If it is the military officers themselves manage the process. But in Terengganu, when this particular election was conducted, it is a matter of fact that although they were being processed by the military officers and the police officers, the respective agents were allowed to be there. The members of PAS were allowed, 2 members of PAS were allowed, 2 members of Barisan Nasional were allowed to be there, and I think there was also an agent for a particular independent candidate. But in spite of all that, we've got serious complaint from my client, who happens to be, thank you. So we know that this particular issue that we have taken in the Terengganu election petition in relation to the postal vote quite clearly show that it is not merely the monopoly of Barisan Nasional, for instance. They could say that certain part of the system benefits them or that it benefits the other party. Now, Mr. Chairman, I didn't realize that I've so quickly taken up with that. Yeah. Now, perhaps I should.
The bell is not loud enough there.
Yeah. Now, the last thing which I need to mention is this. Last 2 things, Mr. Chairman, if you could allow me, very important. Morgan and Simpson seem to have laid down one principle. If you comply with Morgan and Simpson, and I gladly said I will adopt Morgan and Simpson, although I was still fighting for my client, because my argument was this, that even if we follow Morgan and Simpson did put a proviso, and a statement in the end says, whatever is the case, if you cannot show that the election is a sham, then you have no business declaring it null and void. And sham meaning, within the context of Morgan and Simpson, a sham election means there's no secrecy in the ballot box, and that the process is not democratic, namely the counting has been completely irregular. So these are the only two situations where a sham election can be declared to be, in fact, null and void. And lastly, Mr. Chairman, if I may say this, it has always been my, I've always wondered why, at the end of every election case, and I've appeared something like about 70 election petition cases. Not many by world standard, but quite substantial enough for me to appreciate the various gamut of kind of issues that will appear in an election petition. I have always wondered, with the exception of Tanjung Putri case, election judges never bother to suggest that in the course of them hearing this election petition, they find this particular provision seems to have certain defects, as an example, or that this process seems not to be fair to either everybody or to a particular party, or that, for instance, a particular provision seems to not discourage corruption because it seems to encourage corruption. For instance, I'm saying this, I'm yet to come across one member of the judiciary, apart from Tanjung Putri's case, that really says that. And if we could have judges more alert and alive to these issues, perhaps we will not really need outside forces to suggest this. I'm grateful and thank you very much.
Thank you. I think the earlier clap was for the very good point he made, rather than the timing he took. But let me say, I'm struck amongst many of his points, one issue. The best way is to go on a petition, implying maybe that's the best of all other ways. That's a significant point. At the same time, Dato', you mentioned that we don't have caliber judges like the late Wan Yahya. Alive, sorry, he's still alive. He was a late judge in practice. Now he's in retirement. But you don't have the people of that caliber. Maybe that's the reason why people are reluctant to take petitions up to the judiciary. Because there is a perception, right or wrong, that there's a problem of competency and independence. That's my view, and we can debate it. But thank you very much, Dr. Shafi. Now what we'll do is, you all have come here, you have listened to these wonderful presentations, and I'm sure you want to make your own comments. So we will allow 3 minutes each or so. And the bell, please ring it louder. Because some of us older people can't hear as well. I can't, I didn't hear that too well. To be able to say, make a comment in 3 minutes, can I just, if you agree, allow some of the former Sohakam and Proham members to make a comment and I'll come back. What about Judge Vora?